Hello everybody and welcome to the A to Z of international law. What we're going to do in this video is take an introduction and start by looking at the first of our A to Z concepts, which is the active state doctrine. So what we'll do is we will define what the active state doctrine is, we will look at some of the core principles associated with it, some of the interesting case law, and think about how it has developed not only in the United States, but also in the United Kingdom, and recently being rejected in Canada. I say recently because in the last 5 years, rejected in Canada. So fundamentally then, the active state doctrine is the principle in international law which establishes that one country's courts should not question or potentially invalidate the official sovereign acts that are performed by another recognised government within its own territory. That is what the active state doctrine essentially tells us. Simply put, courts of one sovereign must respect the independence of another sovereign. That is the basic idea here. Now, this has a very interesting history, but essentially its most famous formulation comes from the United States and from the United States Supreme Court and the federal law concerning this particular topic, where the US make it very clear that US courts cannot pass a judgment on the validity of foreign state acts that are done in the foreign state's territory. That's the basic idea that we see with the acts of state doctrine. Now, the US legal position on the acts of state doctrine was first elucidated in the case of Underhill and Hernandez in 1897. In this case, the US Supreme Court declared that, quote, courts of one country will not sit in judgment on the acts of the government of another done within its own territory. So this is the first formulation at the federal level, at the level of the Supreme Court, that we see the establishment of the acts of state doctrine. But it doesn't go away at any point. It continues to develop and actually gain a definitive expansion in 1964 with the case of Banco Nacional de Cuba versus Sabentino. This is the case which solidified the doctrine when the US Supreme Court refused to challenge Cuba's expropriation of US-owned property, even amid allegations of violations of international law. For those of you who want to know more about this, go and look at some books on the Cold War, things like the Bay of Pigs and the Cuban Missile Crisis. The US's relationship with Cuba, especially in the 1960s, was quite fraught and quite frosty, let's just say that. And one of the things that Cuba did was expropriate US-owned property that was in Cuba, that was positioned on Cuba. Now, there were allegations that this expropriation was a violation of international law. The law of expropriation is something that is very well established, but the US Supreme Court refused to challenge this expropriation order under the basis of the acts of state doctrine. Their justification being that it doesn't really matter if there's an alleged violation of international law on the part of Cuba's national government. They are the valid government in Cuba, and we as the United States Supreme Court should not question, should not sit in judgment on the acts of the government of Cuba when the acts were committed within Cuba's own territory, which of course the expropriations of US property were. Now, the final point I want to make mention of when thinking about the US position and the US Supreme Court is the case of W.S. Kirkpatrick Incorporation versus Environmental Tectonics, the case of 1990. This is a case which clarified the doctrine only applies when adjudicating a sovereign's act's legal validity, not simply disputing its motive. So thinking about whether or not the actual act itself, the actual legal concept that was initiated by a foreign state, by a foreign government, was legally valid or not. That's essentially the point of this idea. And what we can then do is think about this in more broad confines and more broad context, and think about the scope of this rule. Well, the first thing that should be noted is that it only applies to official acts. It only applies to actions by foreign governments or their organs in their sovereign capacity. The idea here is that we are recognizing the sovereign capacity of that state acting in its own territory, and so where official acts take place that we might not agree with necessarily, we are not to challenge it as the United States Supreme Court. There is also a territorial limit. Note that when we talked about the cases that we examined, Underhill and Hernandez and the Cuba case, it was concerning, especially the Cuba case, for example, as the illustration, was concerning Cuba's expropriation of US-owned property inside Cuba, which means that the state's acts must occur within the foreign state's own borders. Acts abroad, such as foreign commercial activity, will typically fall outside of this doctrine. And then finally, the foreign government must be recognized by the forum state at the time of the act. So the US Supreme Court and the US federal government, for example, in elucidating the acts of state doctrine, has to recognize the government of the other state that is performing the action. Okay, so if, for example, they did not recognize the Cuban government at the time, or let's say some other party that was not part of the government decided to expropriate those funds instead in Cuba's territory, then this might invalidate the act of state doctrine in this particular case, and actually might allow for the US to pass judgment, the US Supreme Court to pass judgment on that particular decision. Essentially, the idea here is we're talking about acts of states. Foreign governments must be recognized by the foreign state. Now, this is a very interesting rule, and it's one that in fact does exist in other jurisdictions and has been suggested in other jurisdictions as well. I'm going to use the two examples of the United Kingdom and Canada. In the UK, then, the Act of State doctrine does exist, and it exists as the Foreign Act of State rule. But it includes a public policy carve-out and may sometimes even apply to acts outside of territorial boundaries. This is an interesting sort of elucidation of this rule. Essentially, the most pertinent example of where this rule exists is, of course, in the United States and within the jurisprudence of the US Supreme Court. But there are similar features of these rules that exist in other jurisdictions, and the UK is one such example. Now, in Canada, we see a very interesting case in 2020, the case of Nevsun and Araria. This is the case which essentially went all the way to the Canadian Supreme Court, and it's interesting in the sense that what Canada did, the Supreme Court of Canada, is explicitly reject the Act of State doctrine and suggested that claims under customary international law in that case could proceed. And so the Act of State doctrine is not something that is a universal principle of all states within international law. It is one that, for the most part, has emanated out of the basic principles of the US Supreme Court. And so it's a very interesting conversation that you can have about the sort of fragmentation of rules and the sort of application of some rules in some jurisdictions versus not in others. But fundamentally, the Acts of State doctrine then does clearly give you some indication of at the very least, the US's position, the US Supreme Court's jurisprudential position on acts that are committed outside of their territory by government inside the government's territory themselves.